Mortgage Corporation versus Engel. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the court. I'm Brian Sutherland for Appellant Freedom Mortgage. I'd like to reserve 2 minutes for rebuttal, please.
You may, sir.
Thank you. The filing of a stipulation to discontinue revokes the lender's prior election to accelerate because the filing is an overt act that is evidence of and discloses the lender's choice to stop seeking immediate payment in full. Under the common law, if a contract does not specify just what the party must do.
I have a question.
Yes, Judge Rivera.
Thank you. All right. So the stipulation and the voluntary and the discontinuance may be for a variety of reasons. If it's actually silent as to acceleration or deceleration, how is the court to ever assess whether or not it really is the basis for the stip?
Well, 2 answers to that, Your Honor. First, anytime that the lender discontinues, whether or not it has multiple potential reasons for doing so, it is going to want to decelerate or elect to revoke the acceleration in any one of those scenarios. So one might be that the lender expects that the borrower will resume making payments, or another reason, the one that the Second Department perhaps has in mind, will be that the lender wants to fix a procedural issue with the case. But in either one of those situations, it has to revoke the election to accelerate in order to do that. And so the discontinuance is evidence of election regardless of the underlying motivation. And the court should keep those 2 questions separate. First, did we make a choice? Have we elected to revoke? And then separately, if there's a question about abusing the judicial process in some way, that should be addressed after the court resolves the question of whether we have revoked and ask whether the borrower has demonstrated that the revocation would cause substantial prejudice. Now, turning to the second part of Your Honor's question, the stipulation here is not silent. It points directly to the foreclosure complaint, and it says we are withdrawing the only vehicle by which a claim for acceleration was made. So it is saying to the world that the allegations in that complaint are not ones that we are seeking to enforce or prove any longer. And what the Second Department did here was look at the stipulation in a vacuum. It didn't read it together with the foreclosure complaint. And it said, well, where is the terms of the loan? But parties wouldn't ordinarily put the terms of the loan or statements about whether they'll be accepting monthly installments or not in a document that is going to become a court order. If they do that, the terms of the loan are then part of a court order and subject to judicial supervision. And then there could be a contempt motion because Mr. Engel didn't pay his monthly installments, or maybe he's bringing a contempt motion against us because we're not accepting his monthly installments. So the parties aren't going to want to put the terms of their loan in a stipulation to discontinue. Also, at 2013, the time of the stipulation to discontinue.
Judge, I have a question.
Yes, Judge Fahey.
Thank you. Mr. Sutherland, one of the distinctions that is drawn by the Second Department opinion and in some of the briefs is a distinction between the note and the foreclosure action. And the way I understand that argument is that the basis of the right to accelerate the debt is in the note, in the contract, and the basis in the foreclosure action simply is a separate proceeding, and you cannot use a judicial remedy like a foreclosure action for failure to do something as the basis of a contract action, and that appears to be what's being done here. That problem may be solvable, but it seems that what they've suggested is it's solvable by simply providing notice to any party, and the notice would be that you've got to expressly say what you're doing when you do it.
Well, Yes. If the problem is solvable simply by giving notice, that presupposes that we have the power to revoke.
Yeah,
which is
but
something.
that's not my point, though.
Yes,
My
you're
point is that your position requires an implicit understanding of the accelerated debt and the voluntary disclosure the voluntary discontinuance. And that should be, and their point is, as I understand it, is it must be expressed. And if you think about it in a larger context, in this court's jurisprudence on contract law, pretty consistently talks about the express nature of contracts, and that whenever anyone's rights are in play, that you have to expressly lay it out. And once you do that, once you've expressly done that, then you may go ahead and voluntarily discontinue. That's the way I understand it. And so wouldn't it be more in line with our jurisprudence to require not that you cannot voluntarily discontinue and to accelerate or not accelerate the debt, but that whatever you're doing, that it be expressly laid out there and not implicitly laid out there?
Well, Judge Fahey, let me see if I can answer your question. I think that this court's jurisprudence doesn't say what a party must do to exercise a right under a contract. And I'm referring to the court's decision in Albertina Realty, which says we need not just decide just what a party must do to exercise.
Let me stop you there. Doesn't Albertina Realty refer to an unequivocal overt act? And the way I understand your argument is that the voluntary discontinuance is a overt act. Am I right about that?
It is an overt act.
Yeah. All right.
Yes,
so let me take it further then. If that's the case, then how is the other party, and honestly, quite often, many of these people are pro se litigants, how are they to know what's happening without it being expressly stated in the discontinuance itself? Doesn't seem to be any great burden on you.
Well, the burden that the Second Department imposed didn't exist in 2013, but here's how the borrower is to know. Even a pro se borrower, and Mr. Engel certainly is not one, he's a non-resident landlord real estate investor and he has private counsel. But even a pro se borrower knows that we have stopped an action for immediate payment in full. Given that we have stopped the action for immediate payment in full, it stands to reason that we are no longer seeking immediate payment in full. The lender needs the judicial action in order to obtain that immediate payment. Without that judicial action, it cannot obtain the immediate payment. Or
Chief,
put differently,
I have a question when he's done.
Please continue your answer, counsel, and then we'll move to Judge Feinman.
yes, Your Honor, just to conclude, there's no rational reason for a lender to forego the judicial enforcement and continue to seek immediate payment in full. Certainly there's no evidence in this record that Freedom Mortgage continued to seek immediate payment in full after the discontinuance. Yes, Judge Feinman.
So I actually have two different questions and answer them at your leisure. Part of your brief, I think, discussed the nullification theory based on Loeb, but I don't hear you arguing that today. Is your principal argument going to be the overt act of discontinuance and that theory?
The reason why Loeb is important is because the common law provides that a discontinuance nullifies the prior action, and even pro se litigants are charged with knowledge of the common law. And that's what makes the discontinuance particularly clear evidence that the lender has made a choice. And what Mr. Engel has argued is that the parties need to enter into a contract to extend the limitations period. And we reject that framework because we're dealing with different causes of action, one that accrued in 2008 and one that accrued in 2013, if indeed we are able to revoke an election to accelerate. And so we think the question ought to be, is there evidence in this record from which a reasonable person could conclude that, that Freedom Mortgage revoked its acceleration? And part of that is the common law says that when you discontinue a prior action, you are nullifying what was done therein. So it is, in fact, a clear message, especially to a counseled borrower, that we are withdrawing and no longer seeking to prove the allegations of the complaint. And again, the complaint is—
I have a question, Chief Judge. I have a question.
Please.
So, counsel, just to be clear, if I take your argument to its logical conclusion, it means that there would never be any limit on how often you could accelerate and decelerate. You could do this every other month, that there's a default. Is that your position, that there's never an end to this? It seems to be somewhat beyond what any statute of repose would allow for.
Two responses, Judge Rivera. There's absolutely a limit. Separate the questions, whether we revoked, from the question whether equity should intervene to stop the revocation. If a party is abusing the judicial process by revoking again and again and again, then yes, equity should absolutely intervene and stop that. But that is not what happened here. Mr. Engel is the one who abused the judicial process. He had actual knowledge of our foreclosure complaint.
So how many times do we say, now that would just be inequitable? Now that's abuse, because would you not be doing this every time there's a default, which your position is, and it doesn't seem wrong to me on its face, but that is your right under the agreements with the debtor.
It is our right. I'm only acknowledging that there could come a time when a lender is abusing the judicial process. Certainly not our case, but the scenario that some of the amici, and I think Mr. Engel also posit, is that the courts will necessarily be subject to endless revocations followed by more accelerations, simply will not occur because the courts can act in equity to block the revocation. But that scenario is entirely distinct from the question whether any evidence of revocation exists in the first instance.
Chief Judge, may I ask a question?
Yes.
I want to understand this a little bit better. First of all, if a lender were to continually discontinue or revoke its acceleration, at least the periodic payments, say the monthly payments, for which the statute of limitations would have run, they can no longer be sought the next time they accelerate. Is that correct?
Yes, Your Honor, that's correct. And that,
I'm sorry, but the other thing is that I just want to clarify as well that when you talk about nullifying what's occurred in the action, you're not actually nullifying the acceleration itself, but you're saying we want to stop the acceleration that we did in this complaint and no longer seek to enforce it. Am I correct in understanding you?
Yes, that's our position, Your Honor. I think the discontinuance is particularly clear evidence of our choice. We're no longer seeking immediate payment full. And yes, it is an important point. The two actions are different because in the second action, we are no longer seeking monthly installments that are time barred. So the two actions seek different amounts. The acceleration in each one is a substantive conditioned precedent to the borrower's obligation to pay.
And if the borrower has changed its position in reliance on your acceleration, would that give a court the authority to disallow it or to not recognize it as valid?
100%. That's the Kilpatrick case and other cases that follow it. If the borrower showed substantial prejudice in reliance on our acceleration, then we could not accelerate again. So I think there are at least two possibilities for blocking the revocation in order to prevent the nightmare scenarios that the borrower would posit, prejudice to the borrower or abuse of the judicial process. Either one, absolutely not present in this case.
Judge, if I can ask one last question.
Yes, Your Honor.
Thank you. Okay, so counsel, what is the burden in just sending a letter to the debtor confirming you've decelerated? What is so difficult about doing that? That would make it clear to everybody what your intent was. Wouldn't have courts wasting their time on any of the equity issues in that way, other than, as you suggest, if there's abuse. Why not just do that? It's one piece of paper.
Those requirements didn't exist in 2013. And if you think about it, a letter wouldn't have been enough in this case because the foreclosure action would continue. The discontinuance is the only thing that could stop the request for immediate payment in full.
No, I'm saying in addition to the discontinuance, I understand your point that you don't want to include every term in whatever your stipulation is. I understand that. It makes total sense. but then why not put it in writing and archive it that way moving forward?
Well, you know, I think that the second department had the same question and said, well, why not include a whole bunch of different statements? We could not have anticipated that requirement in 2013 when we discontinued. Yes, it's something that lenders can do going forward. It's something that I assume they are doing and will do going forward. The requirement didn't exist then, and there was no reason to believe that it did exist. I think that the answer that I gave is probably the most explanatory one, that parties don't want to put the terms of their agreement, including whether they're going to accept monthly installments or not, in a document that will become a court order. And that explains why they didn't do it in 2013, Your Honor.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors, and may it please the court. A stipulation of discontinuance is simply a contract to terminate a lawsuit. That's it. When a stipulation of discontinuance in a foreclosure action is silent on the statute of limitations and doesn't contain the borrower's express acknowledgement of the debt and promise to pay, it cannot have any effect on the statute of limitations. And a court can't imply a revocation of an acceleration into a stipulation which says no such thing. You know, the
Chief,
mortgage notion.
Chief, may I ask a question?
Judge Garcia, yes.
Counsel, would you agree, you know, along the lines of the questioning that's just been going on with your adversary, that if a letter or a notice had been sent at the time of the stipulation, that would have been sufficient?
No, for the reason, again, that there is no unilateral right of a party to affect the statute of limitations. So while the lender may de-accelerate, the operation of that de-acceleration cannot affect the statute of limitations.
Assume that argument is rejected. For purposes of this question, what would your answer be?
It would require an unequivocal overt act. And the mere, so yes, so if the letter contains express language saying, we hereby de-accelerate the loan, you may resume making monthly installment payments of X, which we will accept, then yes.
So how would that address the problem of repeated acceleration and de-acceleration if the only extra step is to send a letter?
Well, that's why I guess our primary contention is that unilateral de-acceleration cannot affect the statute of limitations because, again, a litigant has no vested right to unilaterally manipulate the statute of limitations. There is a means that the legislature
So really,
has
your
prescribed.
whole argument is premised on that first point, that
Correct.
they have no right to accelerate, they have no right to de-accelerate, and after that, it's, you know, that's your primary argument.
Well, they certainly have a right to accelerate under the loan documents. It's that they have no right to unilaterally de-accelerate as a means of extending or manipulating the statute of limitations.
Understood.
Well, Chief, I have a question.
Judge Feynman?
How do you know whether they're doing it I mean, doesn't that drag us into some sort of morass of getting into their intent? Are they intending to manipulate the statute of limitations? That's part of the concern that I have about not having some bright line rule.
So certainly under the rule announced by the appellate division, again here, let's not lose sight of the fact that a stipulation of discontinuance is a contract governed by contract interpretation principles. So if there was an intention to revoke the acceleration, the time and place to do so would have been to expressly insert it into that discontinuance. So really the rule advanced by Freedom Mortgage would turn summary judgment jurisprudence on its ear by saying silence leads to a question of fact, but that's just not consistent with our summary judgment jurisprudence. Silence in a contract doesn't create ambiguity, and omission doesn't create an ambiguity.
Counsel, is there any evidence in the record that Freedom did not intend the discontinuance to de-accelerate the debt?
Yes. In fact, there's an admission at Appendix 156. This is Freedom Mortgage's memorandum of law in support of their summary judgment motion, where they disclose that the reason why the 08 action was discontinued was, quote, the 08 action was eventually set down for a traverse hearing and discontinued 4 years after the commencement of the action when the process server was unavailable to testify. So again, they were confronted with the potential dismissal of the 08 action on personal jurisdiction grounds. A dismissal on jurisdiction grounds does not afford a lender the 6 month savings of the statute of limitations under 205A. So they perhaps saw the writing on the wall and said, let me not double down and roll the dice on the Travers hearing. So, I mean, and that admission is again repeated in the record at Appendix 163, where prior to the Travers hearing, the plaintiff stipulated to discontinue the 08 action due to the defective service on the defendant. So again, the notion that a discontinuance is always, as a matter of law, embodied the embodiment of intention to allow the borrower to resume making monthly installment payments simply is flatly contradicted by this record. And then even taking it out of the larger context, both Mr. Engel and the Legal Aid Society and Nishi have cited collectively about a half a dozen cases where lenders have discontinued because they find some procedural defect with their action, be it a failure to serve the 90-day notice under 1304, the failure to acquire personal jurisdiction, robo-signature documents, the failure to verify the veracity of signatures. So again, under the rule announced by the Appellate Division, what's so unworkable about expressly indicating to the debtor, we are revoking the acceleration because we intend for you to resume making monthly installment payments?
Chief, I have a couple questions if you allow me.
Yes, of course.
Counsel, the answer you just gave suggested to me that the lender's reason here was in fact to revoke the acceleration so as to extend the statute of limitations. So I'm not sure that the evidence in the record you're pointing to supports the point you're trying to make, but if you want to address that, you can. The question I have for you is this. Putting aside your argument about unilateral ability, so just put that to the side for a minute. Assume that the lender here has unilateral ability. What is the difference between a rule, prospectively, a rule that says a voluntary discontinuance of an action automatically revokes an acceleration, and a rule that says you must say in writing to the borrower, we are revoking the acceleration? What is the practical difference between those two?
Because in the absence of an express indication to the borrower that the loan has been deaccelerated, the borrower is none the wiser as to whether it may resume making monthly installment payments and the lender will accept them. Because acceleration and deacceleration affects such a sea change in the debtor-creditor relationship under the loan documents. You know, once a loan is accelerated, the creditor has no obligation to accept monthly installment payments. So if the borrower is essentially left in the dark, in purgatory as to whether they can resume making monthly installment payments, for all we know, look, a borrower be able to pay the full accelerated amount, but may be able to afford making the $2,000 monthly installment payment. So again, we beg the question, what's so unworkable in that circumstance of a rule which simply requires the creditor, if they intend to deaccelerate, to expressly state that to the borrower?
Chief Judge, may I follow up on that?
Stein?
Just following up on Judge Wilson's question, but so what's the difference? Because if the rule is that a stipulation of discontinuance or notice of discontinuance revokes the acceleration, then the borrower will know that they can make their monthly installment payments until such time as the lender re-accelerates, and that's the rule. So how, I don't understand how that leaves the borrower in some kind of situation where they don't know what the rule is. They make their payment, and unless the bank gives another notice of acceleration, it's accepted. And if it's not, then they can raise that in court the next time that they're brought into court.
Well, here again, we have a discontinuance, a stipulation, so which requires two to tango, so to speak here. So you have Mr. Engel, who had every right to insist upon going forward with the Travers hearing, rolling the dice, if you will, and if he was successful with that Travers hearing and the statute of limitations had expired in the interim, the claim would undoubtedly have been time barred because there is no 6 month savings for a jurisdictional dismissal.
Unless the bank made a motion to discontinue and the court granted that motion. Doesn't that put the borrower again back in the same position?
Well, again, a motion for discontinuance, if it's purely intended to avoid an adverse result, I think the outcome would have been the same here. A litigant can't use a discontinuance as a means of evading a possible adverse result. They made their bed, they have to lie in it. So again, imposing, or by implication, a waiver of the statute of limitations or a revocation of the acceleration in a stipulation which says no such thing is, in the context of Mr. Engel's loan, inherently unfair because he forfeited a potential defense. I guess in the larger context of borrowers in general, the statute of limitations is not only a defense, but it's the foundation of an affirmative right to relief to discharge a mortgage under RPAPL 15014. I guess for those two reasons, the need to expressly indicate that is essential, because for all we know, Mr. Engel would have never stipulated to it. And the fact that I guess we have a virtual room of lawyers here pondering whether he would or wouldn't really shows how unworkable the rule advanced by the bank is, when would have been very simple had the parties intended to do so, to embody that in their contract.
Chief, may I try again?
Yes, Judge Wilson.
Counsel, I think that your answer, it goes back to what Judge Garcia was asking at the beginning, which is your whole argument depends on the proposition that both Mr. Engel and the bank have to agree. Otherwise, I still am not understanding what the difference is between the bank sending a letter saying we are unilaterally revoking the acceleration and a rule that says a stipulation does that.
Well, again, if revocation, because revocation has the effect of delaying, postponing, or accruing the statute of limitations, that also implicates New York public policy, right?
Can that be done unilaterally? The question is, can that be done unilaterally? And it seems to me you think not. But if the answer to that is it can be done unilaterally, I'm not sure where your argument goes.
Well, again, because, and I guess, so that simply begs, I guess, we can't avoid the 500-pound elephant in the room, so to speak, as to whether it can be done unilaterally. And it would appear under Flagstar, at least unilaterally as a means to have any effect on the statute of limitations, the answer would be no. Because, again, while Flagstar indicated that freedom of contract is alive and well in New York, when the form or effect of that contract would be to postpone or delay the accrual of a claim under the statute of limitations, then the freedom of contract must yield to the public policy embodied by the statute of limitations. And that's the very effect of de-acceleration.
Yes, Judge Stein.
Yeah, my question is did you raise that in the Supreme Court in this action?
Well, in the essence, look, that's a purely legal argument under the preservation jurisprudence. So I think the court can and should reach it because, again, it's a purely legal argument which couldn't have been avoided by factual countersteps or any discovery. It's really a question of interpreting an unambiguous document, the stipulation of discontinuance, or the loan documents themselves, holding them up against the public policy of New York and against statutes such as CPLR 201, which say that no court may extend the statute of limitations. Statutes such as CPLR 203, which is in essence say that statute of limitations jurisprudence for a court is a matter of simple arithmetic. Find out when the claim accrued, find out when the claim was interposed.
Judge, if I may ask a question, please. Thank you. Okay, so counsel, if I'm understanding what you're trying to argue here, putting aside the preservation question for one moment, it seems your position is that you get one shot at that acceleration unless the parties then agree that you get more than one shot at that acceleration. Is that the way you view this?
As a means of affecting the statute of limitations, yes, because...
Well, then let me ask this. No, I understand the rest of the argument. So then let me ask this, and it may violate all rules of contract and what we understand of mortgages, but I'm just going to put it out there. So why isn't it that what happens is that the financial institution loses the opportunity to raise a claim to assert acceleration, right? They lose that right, but not the right to keep demanding payments. So they can't call the whole debt in, but the debtor is still on the hook for those installments. Why can't it be viewed that way?
Well, again, I mean, because the operation of de-acceleration, unilateral de-acceleration, would be to extend or postpone the accrual of a claim, we have statutory provisions which are entirely on point. General Obligations Law 17-105. There, the legislature has essentially prescribed a scheme for how borrowers and lenders, if they truly intend to agree to de-accelerate, can do so. So the fact that the legislature went to the trouble, if you will, of enacting this whole scheme for a court to recognize a practice.
No, but all I'm saying is again, what doctrines, what rules would prevent one from seeing what is extinguished is the right to seek acceleration in the future, not the debt, not the promise to keep paying the money that was borrowed plus whatever interest it is. But all
Well, look, I guess under our
is the request that I want it all paid now. I'm not going to do this on installments. I'm not going to give you more time. I want it up front.
Again, look, I guess under our statute of limitations jurisprudence, right, the expiration of the statute of limitations just merely bars the remedy, not necessarily the right. So the remedy of foreclosure would be barred. I guess the contract right, if Mr. Engel or any borrower was so inclined and so magnanimous, they could continue to make payments. It's just that the right of foreclosure would be extinguished. It's the right to invoke the aid of the court to enforce that accelerated obligation would be extinguished by the expiration.
I'm not making myself clear, and it may be because it's such an inappropriate way of thinking about it, given our doctrines. All I'm saying is, wouldn't that allow, though, the lending institution to continue with every default to seek the payment as opposed to foreclosure? Just seek the payment.
Well, not necessarily, because look, under these loan documents, they're really a hybrid instrument, right? They start as an installment obligation where the borrower agrees to pay monthly installments over the course of 30 years. Then when the lender accelerates, it really becomes a demand instrument. When I accelerate, there's no such further thing as monthly installments. It's now one unitary obligation, which is due immediately. So there's really no way of putting the toothpaste back in the tube, so to speak.
One last question, Judge. I know we're a little over. Thank you. Just so I'm clear on this, the voluntary discontinuance, is that a product of a stipulated settlement, or is it a one-party voluntary discontinuance of the action? You understand what I'm saying?
Correct. Yeah, I get a stipulation, I guess, under CPLR principles, by definition, imparts a two-party agreement.
So what you're saying is that this isn't a pure one-party discontinuance. This is instead an agreement between the parties.
Correct. And I think we've maintained.
All right, so let me take a step back. So that being the case, the way I understood Judge Wilson's question then was, if you're agreeing, why couldn't you include notice in the agreement? Notice of the accelerated of the reversion to a monthly mortgage payment.
Well, then I would agree that to the extent this stipulation had express language of revocation, that would be entirely permissible, because the parties in that instance are allowed to expressly agree, even under the general obligations law, to extend, reset, or postpone the statute.
So am I right in saying that what you're asking for could have been done here in the stipulated agreement? Is that correct?
Correct. Even under the general obligations law, yes, it could have been.
I see. Thank you.
Thank you, counsel. Mr. Sutherland?
Thank you, Your Honor. Mr. Engel's entire theory here is not only one that is unpreserved, but one that contradicts his admissions below. And he said on page 213 of the record that Freedom Mortgage could have revoked its acceleration, and quote, in a simple letter stating that it was revoking the acceleration. That's paragraph 18 on page 213. So the entire theory that he's offering now is simply one that is unpreserved. The purpose of the stipulation was not to enter into a contract.
If I may ask a question, please?
Yes, please.
Thank you so much. Counsel, I'm going to ask you, I think you've heard it, the question I asked Mr. Engel's attorney. Why can't we view it as what's extinguished is the right to seek acceleration of the debt, but not the demand for the payment? Why can't we view it that way?
You can't view it that way because the contract gives us the right to seek acceleration in connection with any one of the distinct defaults. And there's a default anytime a borrower misses a monthly payment. We have a right to seek acceleration in connection with any one of those defaults. And our second foreclosure action is based on a series of distinct defaults that occurred after 2008, all the way through the time of the 2015 complaint. And as
I guess I'm not being clear, and again, it may be because it's a radical way of thinking about it that is not supported by doctrine. My question is, why can't we see, let's say we disagreed with you, and we took the view of the appellate division, and we say the action would otherwise be time barred on the acceleration, on the foreclosure. Why can't we view it as that's correct, but you're still able to seek the payment of the debt. You just can't make a demand for it to be paid up front, for all of it to be paid upon a default. All you get to do is keep asking for the payment.
Right. That is a hard question for me to answer because it's not one that's been offered by any court or any part or even any amicus brief. So it would be something new in this case.
I understand. Is there a contractual provision that prohibits that? Is there some understanding between the parties that prohibits that? Is there some contractual doctrine that would not allow us to look at the note and the mortgage in that way?
Yes, because both the note and the mortgage say that even if we don't enforce a right, we can do so again in the future if we want to do that.
But here you're arguing you did and then you revoked it.
We did.
Say you did, and so the day is done. That is now extinguished. You don't get to do that again.
Right. So our first cause of action is gone, and we can't accelerate again in connection with the March 2008 default, say. That would be barred by res judicata or collateral estoppel, one of those two. Can't accelerate again in connection with the March 2008 default, but we can accelerate in connection with the 2013 defaults, the 2014 defaults, and the 2015 defaults. We can accelerate again under this contract. And I would like to return to Judge Wilson's question about whether there's a practical difference. And the question raises an excellent point. There is no practical difference between a rule that says a discontinuance automatically revokes an election to accelerate and a rule requiring statements in a letter. Either one of those rules going forward means that the bar has notice of what they have to do, but the rule requiring automatic deceleration based on the discontinuance is even clearer because there's not a fight about what the particular language in the letter said. So
I'm sorry, Chief, if I may on this, but counsel, I think if I can circle back to, I believe it's Judge Fahey's initial questioning, that again would mean implying something as opposed to adhering to our doctrines of contracts, which require express statements.
Well, to be also clear,
difference.
We don't need Judge Wilson's rule to win. Under principles of contract, we win because the evidence discloses that the lender made an election. That's the point.
But
Judge Fineman?
It's just to finish up. So I want to be clear. Under Judge Wilson's rule, it doesn't really matter, whether it's a stipulation or just a voluntary discontinuance. The discontinuance puts you on notice as the borrower that you now have the option to resume monthly payments.
Yes.
That you're advocating.
Our position is that a motion to discontinue is an overt act by the lender. A stipulation to discontinue is an overt act by the lender. A letter from the lender to the borrower is an overt act. What you're looking for, in my view, is evidence of an election, not a contract to extend the 2008 limitations period. We're dealing with an entirely separate limitations period, one that began in 2013.
Thank you, counsel.
Thank you, Your Honor.
The next appeal on this afternoon's calendar is appeal number 2, Ditech Financial versus Naidu.
Good afternoon, Your Honors. May it please the court, I'm Christina Lavorsi, and I'm appearing on behalf of the appellant.
Ms. Lavorsi, would you like to reserve some rebuttal time?
Yes, 3 minutes for rebuttal, Your Honor.
You may have 3 minutes.
Thank you. Given the similarities between our case and those that were set forth in Freedom Mortgage, namely that both actions involve a stipulation of discontinuance, I'm just going to take a few moments of the court's time just to expand upon a few of the arguments that were made by Freedom Mortgage in their case and a few of the points that were raised by the court. I first wanted to advocate for the court accepting a bright line or creating a bright line rule here, that the timely filed stipulation of discontinuance, which was the case in our action, is sufficient to revoke or nullify, whichever language you would prefer to use, in and of itself without any further language having to be provided in the stipulation. And to answer the court's question earlier, I don't believe that because the stipulation itself doesn't expressly say that we hereby revoke, that it's silent on this issue. Albertina, this court in Albertina made very clear that the overt act was the filing of the summons and the complaint. And the converse of that, the overt act of revoking that acceleration would be the discontinuance here, which was a stipulation agreed to by respondent through counsel. It follows that this makes a clear rule for the parties to proceed going forward. The court had asked the question about whether or not, in addition to setting forth something in the stipulation or just filing the stipulation, why wouldn't the lender also provide a letter or some other notice expressly stating that the acceleration had been revoked? And the problem with that approach, and I think Mr. Sutherland touched upon that, is that this doesn't create a clear rule. I think it's going to provide more litigation. It's going to be a morass. Was the letter itself, what was provided in the letter, sufficient to put the borrower on notice? Was the letter actually received by the borrower? We're going to have disputes
Judge,
over.
Can I ask a question here?
Yes, Judge Fahey.
Good afternoon. The Albertina question, it's a 1932 Court of Appeals case. And in the midst of the Great Depression, they said that you need an unequivocal, overt act to accelerate the debt. We agree on that, right?
Yes.
Okay. So why don't you need an unequivocal, overt act to decelerate the debt?
I think that's what you have with the stipulation of discontinuance, and I think it meets the Albertina
requirement. So let me
requirement.
stop you there. An unequivocal, overt act, the way I understand the English language, is that's something that lays out clearly what you're doing. One accelerates, the other decelerates. So if it's good for the goose to require acceleration, why isn't it good for the gander to require an unequivocal, overt act to decelerate?
Right. And going back to your point, I think the term overt, as it's being talked about in Albertina, talks about something that's open and observable. And by the filing, Albertina was talking about giving constructive notice to the parties by the filing of the summons and the complaint. And I think the same thing happens here by the converse taking place.
Yeah, but come on. I mean, overt is overt. You say it to the person. You say, this is the deal. You know, when we're doing this, we got to do it unequivocally and overt. When we're accelerating debt, we got to tell you we're accelerating the debt. So when we're decelerating the debt, why shouldn't we have to tell you we're decelerating the debt? Because you can accelerate the amount of money I got to pay you, but I don't have to tell you that I'm decelerating it. And forget about your protectional analysis, whether it's for service reasons or the statute of limitations. If you have the legal right to do that, you should be able to do that. The only question is, why shouldn't you just have to tell the party? If you got to tell them to do it, why don't you tell them when you're not doing it?
Because I think it's automatically implied. And I agree with Mr. Sutherland that at this point in time, and when our stipulation.
So I'm clear, you're saying that this is an implicit rule?
I do. I believe that it is, even if it's not expressly stated, by the very nature of what a stipulation of discontinuance does, as talked about in Loeb v. Willis, it goes back and it annuls what has occurred in the proceeding. And the proceeding encompasses the commencement of the action, which is the act of accelerating the debt.
Thank you.
Certainly.
Can I ask a question about that?
Stein.
So, are you saying that, as I read Albertina, it clearly didn't require specific notice to the borrower? Because it said that the acceleration was effective upon the filing of the complaint. And back in those days, the borrower didn't get notice until it was served. And so are you saying that there is a difference between an equivocal overt act and actual notice? Is that what you're trying to say?
I do. I think that Albertino was talking more in the context of a constructive notice. They talk about the second sentence after the discussion about an unequivocal overt act talks about that it disclosed the choice of the plaintiff and constituted notice to everyone. And while I understand that maybe notice wasn't actually given because it was a commencement by service, the filing actually constituted constructive notice. And typically there would have been a lease pendants also filed, which would have put everybody on notice as well. So it's more of a constructive notice.
I'm also a little bit concerned about your argument that that under Loeb, everything is annulled, including the revocation, because I'm not really sure what other implications that might have for other, who knows, statutes, contracts, whatever. And I mean, would you agree that it doesn't need to annul it, it just needs to revoke it?
Yes, at a minimum, it revokes it. And I would agree with that. And I think in the end, it comes out to the same end. It reverts everything back to an installment contract where you can collect on each installment due and owing. And I think that lends, it contradicts what the court was suggesting, where maybe the lenders might be manipulating the statute of limitations, because that concept that we're going to be manipulating the statute of limitations really writes out of the contract the fact that it's an installment contract and there's still a statute of limitations period, even if the statute of limitations period isn't running from an accelerated debt. You're still going to be losing installment payments. It doesn't behoove the lenders to delay in any sort of way.
Thank you, Ms. Lavorsi. Counsel?
Thank you.
Counsel?
Am I there? Okay.
Yes.
May it please the court, I'm Holly Meyer representing the respondent in this matter. There's two major issues here, and the court's been addressing this for a little while now. The number one is the nullification. The concept is that the acceleration only occurred because we filed the complaint. That actually goes directly against our whole concept of filing suits. This court even stated that in order to have a cause of action, the cause of action creates the right to sue. And when the cause of action has to have all the material elements and facts have to have occurred in order to trigger that cause of action. That must occur prior to the right to suit. And then the right to suit, you then go ahead and file your complaint. In the situation of what is the evidence of their intent to accelerate can easily be found when they drafted and executed the complaint that specifically said that there was an acceleration and the amount now due was the unpaid principal balance. And I would note that the complaint was executed and affirmed by an attorney who affirms the truthfulness of those facts. And that was executed on July 27th, 2009.
Chief Judge, may I ask a question?
Judge Stein?
Actually, I have two questions. Again, and I guess this is part of my theme here today, is I don't see where you made this argument in Supreme Court, but let's assume for the moment that you did. How would one know the moment in which the acceleration took place? The acceleration, according to Albertino, requires an unequivocal overt act. Okay, so, maybe you're right that something had to be thought about and decided before the complaint got filed, but it just, I think it seems to me that you would be really creating a very ambiguous rule about when that statute of limitations began to run.
Actually, under You're looking for a definitive moment in time that you can say that evidences the time that they accelerated. Am I understanding the question correctly?
Well, yes, I think that you know, you can make certain assumptions, or you can look for that exact moment in time, and remember that the acceleration won't always be by commencing an action or by filing a complaint. There may be other ways of doing it. So, you know, we have to look at all of these. So I guess my question is what is your rule, your proposed rule in this regard?
Well, I did argue in the appellate division, I said that the Overt Act had to have come prior to the filing of the complaint, and we could directly go to the date that the complaint was executed as the facts being sworn to and affirmed. That's a definitive date that is acknowledging that the plaintiff has accelerated. It's right there in black and white. There is no ambiguity. There's no question. There's nothing. I would also note for the court that in the mortgage, it specifically states that the lender, if they accelerate and demand that and require I make immediate payment, they may bring an action. There is no requirement that they bring an action once they accelerate. They can make that demand, as we've seen in other cases. Demand can be made by notice. So the webbing the two and marrying the two together so firmly actually brings up the question, well, if acceleration doesn't occur until after you file suit, then how did you have the right to sue in the first place?
Chief, if I might try.
Yes.
I'm having a little trouble following your argument for the following reason.
Yes.
If your point is that ordinarily a cause of action accrues for statute of limitations purposes the moment you have a right to sue, then the first time there is a default and the other conditions in the mortgage are met, for, you know, there may be notice and cure provisions and so on. But once that's met, the cause of action on your theory begins to run even if the lender doesn't want to foreclose. And that 6 years starts running from that point when the cause of action accrued. I don't think that's the way that you know, foreclosure law has worked for centuries.
Well, we're talking, with all due respect, I think we're also talking about the statute of limitations and how many in other areas of law do we find personal injury, medical malpractice cases, many, many different cases where we say as soon as the cause of action accrues, if you don't.
So what I'm really asking is, isn't the law different here because in a mortgage case, you have installment payments? And in essence, there is a new cause of action accruing every month that those payments are due. So you don't have where you would say, okay, the first time that there's a default that meets the terms of the mortgage, my 6-year statute of limitation starts running on a foreclosure remedy. Nobody says that. It isn't until there is some affirmative decision made that the law says you then start to run the statute of limitations. You could have had a cause of action 10 years ago and elected not to pursue it. And that, even though you have a cause of action in the medical malpractice area, in most other areas, yes, that starts your statute running. But in foreclosures, it doesn't. Isn't that right?
Well, in the foreclosures, as Your Honor said, you have the statute of limitations starts to run when payment is due. And when it is still under the installment agreement, each installment that is missed accrues another cause of action. The amount is due. When you're talking about an acceleration, you're talking about now when the entire amount is due. And that is made by the acceleration. And in order to have a cause, like you can't bring an action for an installment payment that's due in 2025 because it's not due yet. The same concept is utilized with my acceleration. If it has not been accelerated, it's not due. So therefore, you don't have the factual grounds for a cause of action or a right to sue. I'm not saying that they don't obtain the right to sue. Our position is it's not married. So the concept that because the complaint and the proceedings get nullified by the discontinuance does not mean the facts that gave rise to the cause of action are nullified. They don't get erased from history.
But the facts that gave rise to the cause of action are not what triggers the statute of limitations running. Isn't that right?
I apologize. I'm not understanding the question.
Sure. You might have facts that could give you a cause of action to sue once there's a default. You might choose not to accelerate and your statute of limitations hasn't yet started running.
Yes.
So it isn't the facts that gave rise to a cause of action and therefore, whether you nullify the facts or not doesn't make any difference to your argument.
Well, our position is that it's the acceleration or the choice to accelerate is the fact. And that choice is evidenced by some definitive act. And if we're looking for a point in time, the first point in time, all you have to do is turn to the time that the complaint was executed. And once you have that determination, you see that the filing of the complaint is not married to the time that there was an acceleration.
Chief, if I may.
Yes,
Sorry.
just come in.
So changing subjects for a moment.
Yes.
I was a little intrigued because I'm not sure I quite followed your argument that automatic revocation through discontinuance is somehow unfair to the lenders. And I didn't know if you...
In that situation, I was talking about lenders who don't want deceleration. There are cases out there where a lender chooses to accelerate an installment agreement, and for whatever their choice, they don't want to revert back to the installment. They simply want to keep the acceleration.
Well, couldn't they then, if that's the case, expressly state that they are not revoking the acceleration?
But then you can't do it's not a bright line rule that it's an automatic, because then becomes a choice again. And what we're doing now is we're putting the burden on somebody, on a lender who has validly accelerated. Now they have to take the steps not to decelerate, instead of saying, well, if your intent is to decelerate, which we argue that there may not be, then that's a burden that shouldn't be there.
Judge, I have a question, if I may. So
Yes.
can you just work through this analysis for me? I'm just trying to make some sense of this. So you're a lender, you accelerate because there's been a default.
Yes.
You've called it all due.
Mhm.
And then you've chosen not to proceed with the foreclosure, right? Discontinuance. You're saying that there might be lenders who nevertheless are still in the mode of acceleration. So they still want the full amount paid. Okay, so how, other than demanding it from a person who has been in default, hasn't paid, and things seem so dire that the lending institution went to court to try and get that full payment, I don't understand how they're in a difficult position, right? That you're saying they want to keep demanding that money, so don't they just go back to court demanding the money? What am I missing?
But there's a gap there. And all a borrower has to do is meet them on the courthouse steps and give them the payment. And before they get a chance to...
Well, the payment in full, correct? Because you're saying that's what they
an
demand.
installment payment, pay the arrears. And now that lender is back to an installment contract.
But can't they then just file, since it was decelerated to accelerate, they've got their installment, now they can accelerate? Or are you saying that?
No, they've got their installment. So now it's not in default anymore and they lose their rights to accelerate. It's something that they...
Until the next default.
Excuse me?
Until the next default.
If there is. But I would also really quickly note that this stipulation is contrary to any intent to revoke, because the plaintiff who wrote it was BAC, and they specifically wrote that all claims of the plaintiff shall be dismissed without prejudice, meaning that all their claims would survive after the discontinuance. And the claim here was that they accelerated and they were entitled to the entire unpaid principal balance. So simply saying that because we entered in a stip, that there was no...
So Judge, if I may ask, so
Yeah.
I just want to understand, as I asked in the prior case, sort of the logical conclusion, the extension of this analysis. Does that mean, if we saw it your way, if we said, look, it's got to be expressed in that discontinuance, or there has to be some other express statement, let's just say it that way. and there isn't. Does that mean that the debtor could go around paying in installments, keeping their eye on the clock, and then when they hit year 6, go into default and say, well, you can't demand any more money from me because you're time barred? What's fair in that?
Well, that's a hypothetical that I unfortunately haven't been able to find. What I usually find is homeowners actually want to get back into the groove. But what happens is that a borrower might lose their job for 6 months. They get back into work. They want to go ahead and start making payments again, but now they can't because they don't have 6 months worth of payments. And then it takes another 2 years if they get a modification. And now we're 2 years down the line with payment penalties and interests and everything else. And they're the ones that are behind the 8 ball, where all they wanted to do in the first place was go ahead and pay their mortgage. We're not looking at something where a borrower sets out to get something for free. What they're setting out to do is have a home. The consequences of the inaction by a lender in waiting 6 years. In this case, the lender who commenced the action waited 5 years without even filing an RJI and then sought discontinuance. I reviewed the statute of limitations, knowing that my client, there was no stipulation in there about the revocation, and we agreed to give up his whatever good position he may have had to litigate the case. We said, no, we won't, but understanding that the statute of limitations is running, the bank will work with us. They either are going to come back and we're going to litigate it again within the next year, or the bank's going to come to us and they're going to work with us. That was the understanding, that the acceleration still was in play.
So if I'm understanding your view then, or your way of approaching this issue, is that that means there's 6 years for both sides, so that the debtor is not going to end up getting any better, more time in this. Is that correct? If there's silence on this question of deceleration, so as you said, and as I said, the clock is ticking.
Yes.
And so the lender might say, well, you know, I'm getting pretty close to those 6 years. I know you keep saying you're going to try and pay, you're trying to pay, you're going through hard times, but I can't risk it. We're done.
And yes, I do agree that it should be on both sides. That's the contract.
Thank you, counsel. Counsel?
Thank you. I just wanted to touch upon a few points very briefly. Judge Stein, you asked the question about how would we know what the time was of the acceleration when the debt was accelerated, if it's stemming from something other than the filing of the complaint. And you wouldn't know. It creates perverse situations. We're taking a look at a filed complaint and then looking at the date of the signing. But what if you start digging through a file and there's a complaint that was signed, but the lender decided not to move forward with the foreclosure action? Or I think you're getting into a morass of potential pitfalls and litigation if there is not a bright line rule. And that bright line rule was expressly set forth in Albertina. An unsigned complaint or a verified complaint that wasn't filed doesn't give constructive notice to anybody, as envisioned by Albertina. The other part that I wanted to touch upon.
Judge, if I may ask, just to follow up on what this was
Judge
said.
Rivera.
So, but you're not taking the position, counsel, that a lending institution could accelerate in advance of filing, right? You can send a letter demanding and saying, I am accelerating with this letter.
Yes, if it complies, yes, you could certainly accelerate in other ways. I think commencement is just one of the ways in which you
So
can
if a lender does that, do they then have to put in writing, if they haven't filed, they come to some agreement with the debtor, do they then have to put something in writing saying we've decelerated? We've come to an agreement, we've decelerated. Do they have to do that?
Are you suggesting if you accelerated by some other mechanism than the commencement of an action?
Correct.
So I think that for all intents and purposes, the stipulation of discontinuance would still apply. Maybe it would be more clear if you've accelerated by a notice of default that you de-accelerate by some letter saying, we no longer are accelerating by way of our notice of default or the letter that we had sent you. But that's not our situation here in our case. And in our case, we had the stipulation of discontinuance. There's no notice of default. Even
Let me ask you this. If you don't do that, if you don't put it in some express writing, right? But the debtor keeps paying installment payments and you accept them, is that then the equivalent of decelerating?
I'm not sure it would necessarily be a deceleration, but it would be some sort of an acknowledgement of the debt, in my view, that they're continuing to pay on the loan. So it would extend the statute of limitations period in that regard.
Thank you, counsel.
Thank you.
The next appeal on this afternoon's calendar is appeal number 3, Vargas versus Deutsche Bank.
Can the court hear me?
I can hear you. Let's wait till your colleague arrives on the screen as well.
This is Patrick Broderick. I see my colleague on the screen. I don't know if I'm visible or not.
You are not yet. Let's wait another moment or so, sir.
Your Honor, it's asking me to restart my video. I don't want to waste the court's time. Could I appear by audio only?
Certainly you may. If you're comfortable with that, the court's comfortable with that.
Yeah, I'm not much to look at. Your Honor, may it please the court, my name is Patrick Broderick. I'm here for the defendant appellant, Deutsche Bank National Trust Company. And I'd like to reserve 2 minutes for rebuttal.
You may, Mr. Broderick.
This case deals with the acceleration or alleged acceleration of a mortgage loan. And as has been discussed this afternoon, acceleration requires clear and unequivocal notice of that acceleration to the defaulting borrower. Here, the letter that was sent to the borrower indicated that the lender will accelerate your mortgage with the full amount remaining, etc. And the First Department found that the saying will accelerate is an acceleration. We respectfully submit that saying that an actor saying that they will take an action is not the same as actually doing that action. We also submit that looking backwards, in this case years later, at a document saying that an action will be taken is not proof that that action was taken. In this case, the First Department, however, found that a letter that said that the mortgage loan will be accelerated was the acceleration, and that the acceleration took place on the 33rd day after the date of the letter.
Chief Judge, may I ask a question?
Yes, Judge Stein.
Counsel, there's a lot of focus on the word will. Assume for the moment that will, that term itself is sufficiently unequivocal. I guess I have a problem with that letter because I can't tell when the letter is saying that it would become effective. In other words, it says that, you know, the expiration of the cure period or commencement of a foreclosure action, and it refers to at that time. So at which time? Is it clear enough? Is that a problem as well? I guess that's my question.
Your Honor, we think that's a gigantic problem, and that maybe the word will, I don't think it's unequivocal, but it's certainly not clear. And certainly the language at the end of that same sentence saying at that time, at what time? Is it at the time after the expiration of the 32 days? Or is it at the time of the filing of the foreclosure complaint? Or is it the time when the lender, by some other means, elected to exercise its option to accelerate?
Can I just clarify one other thing? It's hard to tell from your brief, but I just want to clarify whether, are you conceding for our purposes here that that there was standing to commence the 2009 action, and therefore that would accelerate the debt? Or are you just saying that it doesn't matter because even if it was accelerated in that action, it was subsequently revoked?
The latter. We hotly contested whether or not the 2009 foreclosure case accelerated the debt. And at the trial court level, what happened is after the motion to renew, the trial court said, well, I don't have to get into this, whether the foreclosure complaint was brought by the proper party, because I have a letter here under the First Department jurisprudence, under the Royal Blue Realty case, that letter accelerated the debt. And so the trial court kind of didn't pass on that issue. We would respectfully submit that that is an issue that has not been determined by the lower courts. So we are not stipulating that the 2009 foreclosure complaint operated to accelerate the mortgage debt.
Thank you.
Looking at the letter, it's clear that a couple of things jump out. In addition to the will language is referring to an affirmative act by the speaker. In other words, it says we, which is referring to the lender, we will accelerate your mortgage. Well, that's a statement of future intention. In other words, consistent with the Second Department's decision in the Malone case, it's a future intention to take an action. The action in this case would be to accelerate the loan. It even says we will accelerate your mortgage. Not that it is accelerated, but we will accelerate your mortgage at a future date. And as the Second Department held in Malone, a future intention may always be changed in the interim. We think that sentence is critical in this case because it's demonstrably true. When you say you will do something, it's not the same as actually doing it. You can change your mind in the interim, or it could become impossible for you to act in the interim. What it's not doing is actually taking that action. It's not automatically self-effectuating. And for that reason, we think the Second Department holding in the Malone case and the Adamez case before Malone, we think are the controlling cases on this issue. Here we have a letter that does say we will accelerate, but it does not say when. It does not say that it is automatic and does not provide an amount of that acceleration. From the point of view of the borrower, when you owe someone money, the two most critical pieces of information are, number one, how much do you owe? And number two, when do you owe it? Here, the accelerated amount is not provided in this letter. In addition, it says we will accelerate.
If I may ask a question, Judge, Mr. Broderick, I mean, isn't the point of acceleration you owe everything on, I'm calling in the debt.
That's right, that is the point of acceleration.
So I don't know that that's really the issue. I take your point about the possibility that the lender could change their mind, even though, as the letter is written, it appears on its face at least to put this within the hands of the debtor. You pay, we're not going to accelerate. You don't, because now the default has been addressed. You don't pay, we're going to accelerate. But I take your point being that the lender might, for whatever reason, even if there's not a payment by whatever date is selected by the lender under the law as appropriate, that the lender might choose not to accelerate. Is that sort of where you're going with this argument?
That's exactly right. That the acceleration will occur at a future date that has not been determined and is not apparent from the face of this letter.
So then your view, I take it, is that as a result, you are encouraging, through that understanding of the letter and the language, it encourages the debtor and the lender to work it out. Am I understanding you correctly? Because there's still hope from the debtor's perspective that they could avoid this acceleration.
That is exactly right, Your Honor. We think that that this language, which is consistent with the mortgage contract, is also consistent with public policy, in that by not finding an automatic acceleration with language such as this, it avoids a race to the courthouse by lenders. And in fact, it encourages the two sides to get together. And in fact, the second page of the letter actually encourages the borrower to telephone in to loan resolution to try to work this out. And so rather than being a clear and unequivocal acceleration of the debt, this is simply a letter that is encouraging the two parties to work it out, and that is complying and gives only the option to the lender to accelerate in accordance with paragraph 22 of the mortgage. Moving on.
Thank you, counsel. Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the court, Justin Pane for Respondent Juan Vargas. Before getting into what I believe the court would like to address is how to tackle this will language, I just want to make clear in Mr. Vargas's case, Deutsche Bank itself admitted 5 times in the record that the loan was in fact accelerated as of January 16, 2009 at the latest, and that the loan was still accelerated more than 7 years later in April of 2016. So just to be clear, the record clearly establishes that this loan was accelerated for a period of 7 years. So regardless of what statute of limitations is applied in this situation, by Deutsche's own admissions, 3 of which being under oath by its attorneys, by its own admissions, Mr. Vargas demonstrated his entitlement to judgment as a matter of law. Now, whether or not we go into now the will accelerate, which again, I look forward to making this argument on why this was sufficient, but to be clear, the facts of this case, just in a closed box here, Mr. Vargas proved his burden. He established the loan was time barred, and it was based off of Deutsche's very own admissions. Having said that, going into the will accelerate,
well,
the language, go ahead.
It doesn't that ignore any argument about possible revocation in there? So that it could have theoretically been an acceleration, a revocation, and then another acceleration. So don't you have to talk about the revocation also?
Only if the Deutsche had argued that it decelerated by revocation and then reaccelerated. Nowhere in this record will the court find Deutsche making the allegation that after it decelerated, it then reaccelerated. It never makes that argument.
But so, isn't that the automatic result of the action if it was revoked, and then there's something that came afterwards? Isn't that just sort of an automatic conclusion?
No, I mean this case is proof that in the Angle and the Nadu cases that deceleration does not discontinuance does not automatically equate to deceleration, because
okay, well that's the question of whether there's been revocation, and that's the question that I'm trying to get you to talk about a little bit.
Okay, revocation, I don't believe there was, just because factually the record shows the loan was still accelerated after this revocation. And again, the revocation clearly from the circumstances shows that Deutsche had an ineffectual judgment. It submitted falsely affirmed affidavits or affidavits it could not confirm were true. And the trial court in the 2009 foreclosure action said, well, we're not going to grant you a renewed judgment of foreclosure because you submitted false affidavits to my court. So in the discontinuance papers, Deutsche admitted itself that the sole purpose of the discontinuance was for the recommencement of foreclosure proceedings to pursue a valid judgment. But again, going back to that discontinuance, meaning revocation automatically or otherwise, this particular record proves that after the discontinuance, and while no foreclosure action was pending, that's an important point to make, is that the record shows the loan was still accelerated as of April of 2016 and there's been no foreclosure action commenced ever since 2009. So
Judge,
this
if I
goes-
may ask counsel, so counsel, if I'm understanding you correctly, your argument here is if we agree based on the prior cases with the second department's approach that a discontinuance in and of itself, without, if it's silent on the issue of deceleration, doesn't decelerate, I assume you're saying you win. But if it's an automatic, right? If it's an automatic revocation, you're saying yes, but if they are able to make a decision not to accelerate through their actions, through an overt act, the overt acts exist here because for the entire period of time beyond the statute of limitations, they were seeking to have Mr. Vargas pay the entire amount. Am I getting your argument?
I hope I'm answering your question correctly because it's a little bit long, but
I'm known for that. My apologies.
Well, what Mr. Vargas is positing here is that this case proves that deceleration in and of itself does not automatically, revocation or discontinuance does not in and of itself automatically decelerate, because this record shows that even after discontinuance, Deutsche was still treating the loan as accelerated. And that's the record at 300.
I think you're arguing that even if we adopted such a rule, that it is automatic, that in this case, the lender actually wasn't seeking acceleration. Right? Their intent was, deceleration. Their intent always was to continue demanding the entire amount.
Correct, and the record proves that fact. So that would kind of go back to how it would be tough to adopt such an argument, whereas one of the cases before the court on the argument shows that it's not automatic and that it couldn't be automatic, because in some cases it's the lender chooses to keep the loan accelerated. So again, on the facts alone, this record shows that the loan was accelerated for a 7-year period and that it was not revoked. Now, on the issue of will accelerate, I believe the letter
So if I can follow up, then why couldn't the court adopt a bright line rule that makes it easy in this way? The discontinuance is an automatic revocation, but the debtor may rebut by showing that indeed, on the facts of their case, the debtor did continue to pursue the entire amount.
I believe the bright line rule would make it extremely difficult then to ascertain any specific accrual date, because now you'd have to ascertain, or you'd give the lending institution an inference that they were able to decelerate and that it was timely without establishing when they did accelerate. And then you'd put it on the borrower to then establish that it was on them, even though the lender has all the facts, to tell the court when it was accelerated, that it wasn't decelerated, and give particular dates, which again, as the defense burden to prove statute of limitations expiring, I believe you've given defendants an unreachable goal. I don't think any defendant could meet that standard ever.
Chief, may I follow up on that for a moment?
Yeah, Judge Wilson.
So counsel, suppose the rule instead was an automatic deceleration upon discontinuance, but the next time the lender sends something saying, I want the whole amount, that then is a acceleration by letter. Doesn't that give you then a clear rule about when the reacceleration started?
I'm not sure that it does. And I think this kind of piggybacks off the question you had asked in the last case regarding the general rule, where you had a tough time saying if a lender elects to accelerate that, doesn't choose to exercise their election to accelerate, are we to say that the cause of action just accrues against them even if they don't elect it? Am I correct in saying that's a piggyback off the question you'd asked in the last case?
I don't view it that way, but that doesn't mean you couldn't.
Okay, I wanted to make sure I'm answering your question specifically, but I believe that if your question is that
Would it help you if I try my question again?
It would be wonderful, thank you.
So let's suppose that we adopt a rule that says a discontinuance voluntary, not on the merits, discontinuance of the action automatically causes a revocation of the acceleration. That's a hard, bright line rule. But we also say you can, if you're the lender, accelerate a loan by starting an action, but you can also accelerate it by sending the borrower notice that you are accelerating the loan. that you have accelerated it. Maybe not that you will, but that you have. And if the lender sends something, say, after the automatic deceleration, sends something saying, you owe us the full amount, that is then starts the acceleration again. Could we have that kind of rule? Wouldn't that take care of the lack of clarity issue you raised in answering Judge Rivera?
I'm not sure that it would, because if you have this voluntary discontinuance acting as automatic revocation, well, then you're saying that if the election was made in the complaint, okay, I can understand how it makes sense. But if the election to accelerate was made prior to the complaint, now you're saying that the deceleration or discontinuance vitiates any prior act of acceleration, regardless of whether it was through the commencement of foreclosure or by notice earlier on. So you're now opening this Pandora's box to how far in a continuum of time this can go. But let's just go with that thought. Let's say, okay, the discontinuance is automatic, and then a lender can send a letter saying they're reaccelerating. They absolutely can reaccelerate the loan because it's on the defendant to raise a statute of limitations defense. I mean, it's a waivable defense. So a lender can seek an accelerated, balance, 15 years in the future. If the defendant doesn't raise the defense, they get the 15 years worth of payments. So it's on the defendant to raise his defense, but I'm not sure. I guess I understood the automatic revocation then leading to reacceleration by letter. I mean, again, I think the letter is an easier way to fix a statute of limitations period or accrual. And this is what I guess I was trying to address on your last question, is that the lender does not have to send under a Form 3033 Fannie Mae mortgage, does not have to send a notice of acceleration. If a borrower misses a payment, the lender could start a foreclosure action on the one payment. New York RPAPL provides for partial foreclosure actions. So if they wanted to, they could foreclose on a single payment, 2 payments, 3 payments. But if they want to elect that special rule where they can say, you know what, this loan's mature now. I'm maturing this loan due and payable in full. They have to send out this condition preceded notice of acceleration. And in this particular case, rather than use what the mortgage said you're supposed to use if you're a lender, it says you have to send under paragraph 16C and 22B4 that if I do not correct the default by the date stated in the notice, lender may require immediate payment in full. In this case, IndyMac chose not to use the language in the mortgage because the borrower and IndyMac agreed that the language would be may accelerate. It chose to supplant that with the word will. So again, we have to give effect to the meaning of the negotiation made between the borrower and the mortgage bank on making this contract, is that they both agree that may would be the operative word to say, we don't have to elect it. We're just going to maybe in the future, and that would be equivocal. And I agree, may accelerate would be not sufficient. By choosing will over may.
Thank you, Mr. Payne. Mr. Broderick, we're assuming that you've maintained, you're welcome. We're assuming you've maintained your connection.
Yes, Your Honor. Can you hear me?
Yes, we can. Thank you.
Thank you, Judge. Just briefly, I just want to speak about the alleged evidence that subsequent correspondence on the record here somehow evidences acceleration by the August 2008 letter. There's 2 letters in the record that I think counsel was referring to. The first letter was sent by a law firm during the pendency of the foreclosure case. That letter is on the record at page 37. It's during the pendency of the foreclosure case when foreclosure counsel was under the mistaken belief that there was a foreclosure pending, number 1. And number 2, that a valid foreclosure was pending, I should say. Number 2, it does not refer to the word acceleration. It says nowhere in accelerate that it's an accelerated amount. And it nowhere refers to the August 2008 letter, which is the one we're talking about at issue in this case. So we don't think that letter in September 2013 evidences anything with respect to acceleration. The second letter in the record is after the foreclosure case was dismissed. That's at the record at page 39. That's a payoff letter. Payoff letters have nothing to do with acceleration of loans. Loans that are current, people can and do ask for payoffs if they want to refinance, if they're selling the home, etc. Payoff quote has nothing to do with acceleration. The letter itself that's being referred to in July of 2014 never mentions acceleration, and certainly never mentions the letter from 6 years prior saying that that was the acceleration. So we don't think the record subsequent to the sending of the letter in August of 2008, we don't think the record bears out the argument that the loan in fact was accelerated by that August of 2008.
Judge, could I ask a question? Mr. Broderick, what would you have us look at in the record? What would you point to? What piece of proof would you point to that you would say this letter constituted a deceleration of the loan? What in the record?
We would refer to the, well, we start by saying we don't think this loan was.
Okay, I got that, but let's assume it was accelerated. What would you point us to say it was decelerated?
We would point to the motion to discontinue the action.
Thank you.
Thank you, counsel. The next appeal on this afternoon's calendar is appeal number 4, Wells Fargo Bank versus Ferrado. Good afternoon, counsel.
Good afternoon. May it please the court, Brian Pantaleo on behalf of appellant Wells Fargo. I'd like to reserve 3 minutes for rebuttal.
You may have 3 minutes, sir.
Thank you. This appellant didn't slumber on its rights. This appellant, through multiple actions, avidly tried to enforce its rights and protect its security interest in the mortgage. But the ground kind of moved underneath it. Having to file all of these actions. Whether it was at first just the inconsistent positions in the earlier actions that respondent takes now, whether it was the law of revocation kind of being undone, and all of a sudden the court started looking at pretext, which was not a requirement before. They started looking at what the intent, like a mens rea almost, as to what the lender is thinking when they're invoking a contractual right that this court had recognized for over 100 years, or whether it was the strategy employed by respondent to push this case further and further and further until we actually had a statute of limitations issue. With respect to the first part, the earlier actions, the 2009 and the 2011 actions, the Supreme Court in the 2011 action made a clear distinction. It divided the case into 2, or divided the mortgage instruments into 2. It said that there is a separate instrument, the mortgage alone, and it's a separate instrument, the mortgage with a modification. And foreclosure upon one is not foreclosure upon the other. It said it's not, they're not permitted to foreclose on whatever they choose, or whichever mortgage instrument they choose. And that was a very, very important distinction. And that distinction came after Ferrado argued to that court that these were 2 separate agreements, that that they were suing under the wrong agreement, Wells Fargo was, that the agreement was renegotiated, that the mortgage was amended and
If I may ask a question.
Judge Rivera.
So, counsel, if I'm understanding your argument, given the position taken in a prior action, your position is that the lender can proceed under the original agreement or under the modification. Am I understanding you correctly?
That was not the Supreme Court's position. That was the position that was taken.
I'm asking you about the lender's position.
So this lender's position is essentially that's what we had to deal with, because that's what the Supreme Court said. I have seen no appellate law that actually supports that case. But that's what we relied upon, and that's what the court found, because that's what Ferrado argued.
Did in the earlier actions, weren't you proceeding on the agreement that predates the modification, that is to say the original agreement?
Well, that's what the Supreme Court didn't think that way. The Supreme Court said these are 2 separate actions, and foreclosure.
I'm asking you what the lender was proceeding on. I'm asking you.
Okay, well, okay, so the lender did not reference the modification.
Okay.
And the
so
lender
then proceeding under the first agreement, because you're not mentioning the second one, right?
what the court, yeah, right. The court said that there were two separate, the Supreme Court said that there were two separate agreements. So it
Yes.
determined that they're proceeding on the first agreement. Yes.
So,
Or the wrong agreement.
And
as
if that,
Corrado
is
said.
if that is what the lender is doing, how does that encourage debtors and lenders to enter modifications?
If they're proceeding on the wrong agreement, how does that encourage them?
Okay, so you're conceding now that that would have been the wrong agreement.
No, I'm just conceding that that's what the court said.
Again, let me try it this way. What is the agreement the lender was proceeding under?
The mortgage.
First,
The mortgage.
there's a modification, is there not?
Yes, there's also a modification.
Okay, so does what impact, if any, let me try it this way, does the modification have on the action? On the
Well, in this case, they weren't allowed to introduce it. It was dismissed. The complaint couldn't go forward. There was no answer or affirmative defense. Modification and reformation are affirmative defenses. The court didn't even let it get to that stage. The court said this complaint just can't be moved forward. We can't go anywhere with this. These are two separate and distinct instruments, and it didn't grant leave to amend. Almost by that reasoning, it couldn't have granted leave to amend because it said you didn't have the right instrument when you filed. Now, again, this is not, this was what became the law of the case.
So couldn't the lender file the next day under the correct instrument as the court saw it?
Well, that's what the court did. Or that's what the lender did. The lender went back and attempted to
At what
file.
point? How many proceedings before the lender went back under the modification?
The next proceeding. The next proceeding, which was the 2011 case. This was dismissed in 2010, but you can't, there's all kinds of notice requirements to file a foreclosure. So this was something very distinct. And the court was, with 2017 action, the order that's actually on appeal, when the Supreme Court looked at this order, it understood this in terms of the option contract jurisprudence that had developed in the appellate departments, Burke and its prodigy. And basically, if you have the wrong plaintiff and you don't have standing or you're not a note holder at that point in time, then you can't accelerate the loan, and that complaint is insufficient to do so. Well, here you have a situation where you have the wrong document said by the court. So you don't have standing, or you may or may not have standing. We don't know because it's actually the wrong document, and you can't proceed. Again, that complaint, because it was the wrong instrument, could not have accelerated the right loan.
Chief Judge,
so to speak.
may I inquire?
Judge Stein?
Counsel, are you aware of any other reported cases that involve this situation where the court said that the lender was suing on the wrong instrument as between an original mortgage and a modification?
I do not. There is some case law out there that says if you reference the modification, you can later introduce it into evidence. It's more recent case law. I think it's out of the Second Department. But as far as a court saying, no, we were not going to accept this complaint at the motion to dismiss stage without even an answer, that's about it.
And you're arguing that the court improperly denied your request to recognize an effective revocation with regard to the prior actions, right? When do you say that revocation was effective? When did that take place? Was it when you made the motion in Supreme Court in August 2017, or was it at the time of the Supreme Court order in March of 2018?
It was at the time. So we've spoken for a long time, and we've had 4 cases or 3 cases before this that talked about a clear and unequivocal act. The clear and unequivocal act is when a lender's attorney puts in an affirmation. The basis of this motion is to revoke acceleration. That's recorded. That's true to the world. Everybody can see it, and that's at the point in time that everybody should know. And the court just started to look. This was even before Malone, but this was the first Supreme Court opinion that I'm aware of, where the court looked at this and said, no, you can't revoke in its order. We're going to accept that you're discontinuing, but you, in capital letters, cannot revoke. Again, our position is that pretext really shouldn't matter. All that matters is that clear and unequivocal act, and here you have it in August of 2017.
Chief, if I
Thank you,
might try to
counsel.
Chief?
Yes, Judge Wilson.
So, counsel, I didn't see any rationale as to why the court, so as Supreme Court said, you can't revoke. Was there any oral discussion that would shed any light on that? What the reasoning was?
I was not present at the oral argument, but I do not understand. I believe the argument was, hey, they just want to revoke because they're going to avoid the statute of limitations. And again, our position is pretext really shouldn't matter here if you have a clear and unequivocal act. It's like any other contractual right, and this is a contractual right that's been recognized for 100 years by this very court.
Thank you, counsel. Counsel?
Thank you.
Good afternoon. May it please the court, Catherine Sherman for respondent Donna Ferrato. As an initial matter, the facts of this case, which I'm sure the court is very familiar with, are slightly different from those that you've heard in the prior cases. The bank in this case tried to foreclose upon Donna, Mrs. Ferrato, 5 times, starting in 2008 and the last time being in 2017. Over these 10 years, the bank could not get it right. The first action that they filed, the first action that was filed actually was settled with the loan modification agreement. Ms. Ferrato concedes that that modification agreement was a revocation of the initial acceleration of the loan. However, again, in September 2009, the bank filed a second foreclosure action demanding that the entire debt be paid. Accordingly, they accelerated the loan in September 2009.
May I inquire?
Yes, of course.
Counsel, I'm a little confused. You sought dismissal of the earlier actions because they sued on the wrong instrument. And I assume by that you meant you can't tell from the complaint what amount they were requesting, or if you could, it was the wrong amount. So how does that constitute an unequivocal overt act of acceleration if that is true?
Well, Your Honor, there was one mortgage here and one piece of property that Ms. Ferrato had a mortgage on with the bank. And in fact, both the second and third foreclosure actions, although they did not attach the modification agreement or refer to the modification agreement in Schedule E attached to both of those complaints, they had the correct principal amount due under the loan modification agreement.
Well, but by referring to the mortgage, that would indicate one amount due, and by attaching Schedule E, that would refer to a different amount due. To me, that's the quintessential equivocal act.
Well, it was clear that the bank was demanding that Ms. Ferrato pay the full amount of her loan or her house would be taken away from her. And, you know, the loan modification agreement in and of itself refers back to the mortgage and the note. And there was no indication for Ms. Ferrato that she wasn't going to lose her home if she didn't pay the full amount due. Now, there's a difference between the standard of stating a claim for foreclosure, which is what we argued the bank failed to do, and a difference between what constitutes clear and unequivocal notice that the loan is being accelerated. And
Chief, if I might ask a question there. So when you said failure to state a claim, why did the complaint fail to state a claim? Was it because it was not the right mortgage instrument that was sued on?
It was incomplete mortgage documents. And so it did not.
That affects what? Why is Supreme Court's decision correct?
Well, Judge Kinney decided in the third action, and essentially because the bank had no rebuttal to our argument that it didn't state a claim, because it's incomplete mortgage documents. And, you know, in a residential foreclosure, the bank is held to specific standards of what needs to be included in the summons and complaint to foreclose upon the borrower. And here, the bank just on a technical error didn't include all of the mortgage documents. But at no point did Ms. Ferrado understand that the bank was going to continue to accept payments from her, or at no point did they indicate that they were not accelerating the entire mortgage that was due, the loan. So it is our position that the loan was indeed accelerated by the commencement of the second foreclosure action. Going to the court's second issue that I believe it's been discussing all day regarding whether or not a voluntary discontinuance constitutes a revocation of the acceleration. Not to cut down my colleagues who argued this point previously, but actually in this case, it doesn't matter. If this court decides that a voluntarily discontinued action automatically revokes the acceleration, then it doesn't matter to Ms. Ferrado because the bank started a third foreclosure action in September 2011, 2 years after it commenced the second action with the wrong document attached, and failed. In that case, was dismissed on the merits by the court. So if you count from this third action, then the fifth action filed in December 2017 is still time barred. So that particular issue that's before the court today is not relevant in the facts of the case that is Mrs. Ferrado's. Just to sum up, I would say Ms. Ferrado's been dealing with the bank with this for over 10 years now. It's really disingenuous for the bank to come forward now and to suggest that Ms. Ferrado had some grand scheme to trick the bank in some way. It was the bank's repeated failures and incompetence to pursue the foreclosure in the correct legal manner that has gotten them in the position that they are now, and they've run out of time.
Thank you, counsel. Counsel?
Thank you. May it please the court. This was not a technicality, and this idea that this was the wrong mortgage interest and the complaint could not proceed came after, again, arguments made by Ferrado and her counsel that they were suing under the wrong instrument, that the mortgage was amended and superseded, not wrong documents. The mortgage was amended and superseded by a later agreement containing substantially different terms, that the documents upon which the complaint relied upon were incorrect and, more importantly, of no force and effect. And that's why they didn't accelerate the loan. And if that was the case in 2011, that was the case in 2009 as well. I'm sorry.
Counsel, no, that's fine. So, counsel, but I think her point is that, as you started saying over and over, you are indeed trying to get paid. All she is saying is that, yes, over and over, you're trying to get paid the full amount. That was always what the lender was pursuing, even if, I won't use her terminology, even if each time there's a reason that the court stops them in their tracks. That what the message that they communicated, what they made clear, their action was, we want the full debt paid. We're calling the debt. Why isn't she right about that? That's what one draws from this record, if you look at indeed what the lender did.
Because again, it was a different document and a different set of loan instruments. And if that was true, then that action should have been able to proceed in 2011. It's as simple as that. There is, we didn't want to file 5 actions.
Do you then take the position that the only way that you can accelerate is by an action that is maintained at the court? That if you make some technical error and it's dismissed, that you haven't attempted to accelerate?
We take the position that this is not a technical error nor a technical decision, that this was a substantive error.
If the court disagrees with you, do you lose?
If the
court disagrees and sees it her way about the nature of this error, do you lose?
No, because if you look at option contract jurisprudence, there is an option and you have to provide notice as to the option that you're accelerating from the correct document. There are different interest rates. There are different amounts under the different document, and that is not clear. That is, like Justice Sines said, that's as unequivocal as you can get when you're looking at two different amounts and you have, quote unquote, the wrong document, as the Supreme Court found in 2011, and Ferraro argued vociferously to the court at that point in time. Thank you.
Thank you, counsel. That concludes the arguments.